we are going to continue looking at the powers of the president, that is the legislative powers of the president. Now we are going to look at the power of the president to consult the Supreme Court. So the president under Article 143 has the power to consult the Supreme Court on any legal matter that he deems necessary. So under Article 143, the president can consult the Supreme Court on any legal or constitutional issue. This power includes the interpretation of the Constitution on a specific issue. That is, if the president has doubt as to how a particular article or particular section of the Constitution has to be interpreted, then he can consult the Supreme Court and he can ask the Supreme Court for an interpretation. The views espoused by the Supreme Court on such issues have the power of the judgments of the Supreme Court, and as an extension have the power of law. So such views espoused by the Supreme Court on doubts that have been asked by the president have the power of judgments of the Supreme Court, and by extension the power of law. Please note that it is not binding on the Supreme Court to provide advice. So the next power that we'll look at is the power of the president to promulgate ordinances. So in the previous video we also saw that V.V. Giri consulted Muhammad Hidayatullah for advice as to how he could become the president and what to do in the constitutional crisis that they were in. So Hidayatullah then actually told V.V. Giri that you can resign and then get elected as president through the parliament, through the indirect elections of the president. So even this, that is the power to seek advice from the Supreme Court by the president, is given by Article 143. So next that we will look at is the power of the president to promulgate ordinances. It is a very important topic. We will look at it now. So when the parliament or any one of the houses is not in session and the government feels an immediate need to bring in a law into force, then the president may choose to promulgate ordinances. I repeat, when the parliament is not in session, or if one of the houses is not in session and the government cannot legislate at that point in time, but it needs a law very urgently so that something can be given action, then the president may choose to promulgate ordinances on that topic. These ordinances that are passed by the president have the effect of an act passed by the parliament, and hence they become a law. So the ordinances passed by the president have the same effect as that of a law. The president is empowered to promulgate ordinances under the power conferred to him under Article 123. Please remember, the power to promulgate ordinances by the president is given under Article 123 of the Indian Constitution. The power of the president to promulgate ordinances is an exceptional power. Please remember this, it is not an ordinary power, it is an exceptional power, and it is a legislative power too. It is not a discretionary power. So the power to promulgate ordinances is not a discretionary power. It is a legislative power, it is an exceptional power, but not a discretionary power. The power to promulgate ordinances must be used only when it is absolutely necessary. It is not supposed to replace the legislature as a primary forum of lawmaking. So passing ordinances is not the primary form of lawmaking. The parliament is there, which is the primary forum of lawmaking. The Supreme Court observed this in the DC Wadhwa case of 1987. Remember that ordinances are only temporary in nature. That is, the president can promulgate an ordinance, but this is temporary in nature. Why do we say so? The ordinances that are passed by the president are subject to parliamentary approval. Because the parliament was not in session and the parliament could not legislate on a certain topic, the president promulgates an ordinance. However, once the parliament reconvenes, within 6 weeks, such an ordinance must receive the approval of the parliament. It is within 6 weeks of the convening of the parliament, the bill that was converted into an ordinance has to be approved by the parliament so that it can continue to be a law. If the parliament that is reconvened does not approve of the bill that was promulgated as an ordinance, then such an ordinance lapses and such a bill is no longer an act. That is, such a bill is no longer a law and it is repealed. The interval between two sessions of Parliament can be a maximum of 6 months. So the maximum life of an ordinance without parliamentary approval is 6 months and 6 weeks. I repeat, the interval between two sessions of Parliament can be a maximum of 6 months, and the maximum life of an ordinance without parliamentary approval once the Parliament is convened is 6 weeks. So the total maximum life of an ordinance without parliamentary approval is 6 months and 6 weeks. But please note that the President can re-promulgate the ordinance later on when the Parliament is not in session. I know after that session is dissolved, it can again be, the same ordinance can again be promulgated. There is no bar on this. Moreover, the President does not have the discretion to promulgate ordinances of his own accord. We have already seen before that promulgating ordinance is not a discretionary power. The President does not have the discretion to promulgate ordinances of his own accord. The President is to act on the aid and advice of the Council of Ministers in line with Article 74. So Article 74 says that the President is to act according to the aid and advice given by the Council of Ministers, the head of which is the Prime Minister. So he has to act according to the aid and advice given by the Council of Ministers. Even for ordinances, it is the same. The Council of Ministers must first tell the President that please pass this ordinance. Then the President can choose to promulgate such an ordinance. Please note the use of the word choose. Why do I say this? The President can consider an ordinance only when the Council of Ministers approaches him asking him to do so. Now the Constitution mandates that the President is convinced that the ordinance needs to be passed immediately and cannot await the reconvening of the Parliament. So the President must first be convinced that the ordinance needs to be passed immediately and cannot wait the convening of the Parliament. Second point, the President also needs to be convinced that the government has the necessary numbers in the Parliament to get the bill passed once it convenes. So the President must be satisfied about these 2 points. One is the bill that has to be promulgated as an ordinance is very urgent. It cannot wait till the Parliament is convened. Second, the President also needs to be convinced that the government has the power in both the houses to get the bill passed once the Parliament convenes. Only when the President is satisfied about both these points does the President make the bill into an ordinance. However, if the President is not satisfied that an ordinance is necessary, then he may choose not to promulgate the ordinance. So the President has some control over this. It is not just that the Council of Ministers comes and tells the President to pass an ordinance and he does it. It is not like that. Even the President has to be satisfied that yes, such a law is necessary and it cannot wait till the Parliament convenes. And he has also to be convinced that the government of the day has the power or the number of votes necessary in both of the houses of the Parliament to get this bill passed into an act. So once the Parliament convenes, it deliberates on the ordinance that was promulgated by the President, and then the Parliament votes on it. When a bill seeking to replace the ordinance is tabled in the Parliament, it has to be accompanied with a statement explaining the conditions that had necessitated the promulgation of an ordinance. So now an ordinance has been passed, and then later on after 3 months, let's say, the Parliament has been convened. Now the bill has to be, the ordinance that was passed, the same bill has to be introduced in the House of Parliament. It can be introduced in either House of the Parliament. Once it is tabled on the House, then along with this bill, there should also be an explanation as to why such an ordinance has been passed. What was the necessity to promulgate such an ordinance? Now, the procedure to pass the bill in both the Houses of Parliament remains the same. The ordinance is now deliberated upon as a bill. Then it is voted upon. If it is passed by both the houses, then it becomes an act. If it isn't passed by the Parliament within 6 weeks, the ordinance immediately loses its effect as a law. However, all actions taken on the basis of laws of the ordinance when it was still pending Parliament's decision continue to remain valid. So even if the ordinance is repealed, the actions that were taken when the ordinance was still in force as a law continue to be valid. So what does this mean? Let us say now the parliament is not in session and there is a tax that is 25% right now, and the government feels it is very high and it is harming the economy. So suddenly the government asks the president to promulgate a ordinance that brings down the tax from 25% to 10%. Now a lot of business has happened in the 3 months before which the parliament is convened, and this product has been taxed at 10% and everybody has bought it. Now the parliament refuses, or the parliament cannot pass that bill because the government of the day does not have the strength in the houses. Okay, so this bill does not become an act and the ordinance lapses and the ordinance is no longer a law. However, all the products that were taxed at 10% because of the ordinance, they all continue to remain valid. It is not that that is not valid, and it is not that the products that were bought will now be taxed at 25%. It is not like that. The law was in place, that is the ordinance was in place at that point in time, and the actions that were made in accordance with the law that the ordinance helped come into place will continue to remain valid. So all actions taken on the basis of the laws of the ordinance when it was pending parliament's decision remains valid. It is a very important point, please note it. Also, if a bill is held up in one of the houses of the parliament, reenactment of an ordinance is considered to be a violation of the principles of the constitution. So this is also a very important point. Please remember, if a bill is held up in one of the houses of parliament, reenactment of an ordinance is considered to be violation of the principles of the constitution. So mainly for promulgating an ordinance, it is necessary that the bill is not pending in either house of the parliament. If at any point the president, after promulgating the ordinance, feels that the conditions that necessitated the ordinance have expired or it no longer exists, then it becomes his responsibility to withdraw the ordinance. So the president also has the power to withdraw the ordinance and not just promulgate it. So if the president feels that the conditions that necessitated the promulgating of the ordinance no longer exist or the conditions have expired, then it becomes the responsibility of the president to withdraw the ordinance. Hence, the moral responsibility of the enactment of an ordinance lies with the president. While the power remains with both the Council of Ministers and the President, the moral responsibility of the enactment of an ordinance lies with the President. The ordinance making power does not confer upon the President any additional powers with respect to the Parliament's legislation making powers. So, the ordinance making power of the President does not confer upon the President any additional powers with respect to the Parliament's legislation making powers. He is subject to the same limitation as the Parliament is when it is making laws. So the President's power to promulgate ordinances is equal to that of the Parliament, and the President has no special powers when he is legislating. He is subject to the same limitations as the Parliament is when the President is making laws through ordinances. So an amendment to the Constitution cannot be made using an ordinance. Again, a very important point. Please note it that an amendment to the Constitution cannot be made using an ordinance. So because you are passing ordinances, there is a problem. That is, some people might consider it illegal. So because of this, there is also a judicial review of ordinances. The Constitution clearly says that the President has to be satisfied that there existed a need for the ordinances to be promulgated. The satisfaction of the President is subject to judicial scrutiny on grounds of malafide. So the Constitution says that the President has to be satisfied that there is a need for the ordinance to be promulgated. This satisfaction of the President is subject to judicial scrutiny on grounds of malafide. The Supreme Court cannot question the power of the President to promulgate ordinances. The President can go ahead and promulgate ordinance. There is no problem with it. But is the President truly convinced that an ordinance was necessary, or is he doing it on grounds of malafide? This can be tested in a court of law. This is what the Supreme Court has said. The satisfaction of the President is subject to judicial scrutiny on grounds of malafide. So in a way, the ordinances can be reviewed judicially. This concludes the video on the ordinance promulgating power of the President. We'll continue with the powers of the President in the next video as well. Thank you.